Hi, I'm Mark Andrews, a 53-year-old father of two, and I'm part of the family court legal system. I am also a 13-year veteran, licensed and bonded officer of the court known as a process server. I've worked for hundreds of lawyers, 15 investigators, and 3 judges. I'm also the man who submitted the family court whistleblower complaint to the Congress through Congressman Mark DeSaulnier and Ro Khanna, and they submitted it to the Oversight and Reform Committee, which is opening up talks now regarding family court reform. I've been asked by Kids Matter to tell you about the evidence I submitted in my federal civil rights case, 17 CV 00252, which federal judge William Orrick III, who you probably well know from the first Trump travel ban, ruled in my case that judges have an absolute immunity from suit, even when they're violating your constitutionally protected civil rights. Let's look at that evidence now. So Kids Matter has asked me to present evidence in my case, but I need to give you a little background in my case. My case is 18 years long. I've been in front of 15 judges, 3 commissioners. I've said 73 hearings. I've been hauled into court 11 times by warrant. I've seen my children less than 1 month's worth of hours in that 18-year span. And never once was my ex-wife ever held accountable for not showing up with the children. My kids weren't allowed to come over in the summer. I wasn't allowed to take them to the ballpark. I had to turn around and visit them in a 4-block square radius in the town of Sonoma. And no parent should have to go through this. I mean, my divorce started in 2002. The last time my kids were at my home was the first week in January of 2004. And the last time I saw them together was the first week in April of 2008. And I saw my son for 1 hour after that in a therapist's office, which of course costed $125 an hour. So Kids Matter has asked me to bring to you the damning evidence that I brought in my case that was basically just a cover-up of a judge violating someone's civil rights in a family court proceeding. So I have here 2 transcripts. They're from the same date at the same time from the exact same hearing. They should be exactly the same, but they're not. So let's look at page 1. We look at around line 21. We can clearly see that I'm represented by Public Defender Leslie Cagle. We'll skip over page 2 because it's a superfluous page. And now we're going to go to page 3. And on page 3, we're going to look at 3 sections that matter as we go down and review all these documents. In the first beginning, we see on line 5 that this is a public defender matter. So it requires an attorney to be present for the defendant. Second, we look at around line 16. This is where my attorney starts to speak and address the court. She asked the court about my licensing issue. And if we go down to the line 27, I clearly state to the judge that I should have custody. And this will matter when we look at the second transcript. Both of these transcripts were obtained 2 years apart. The first one was in September of 2014. The second one was in October of 2016 as I went into federal court. But back to the transcript. Let's go to page 4. And in which I asked the court about my license being taken away as an undue burden. And the court says, it's done. There's nothing I can do about it today. I won't today. I don't take it. The state takes it. Also on page 4, another section that is very relevant is down line 22. Now, when you go to court, you usually have to file some paperwork. In my case, I received a notice that they're going to take my license. I responded by challenging the law constitutionally, which would require a state attorney general to get involved and have a hearing. But Sonoma County Superior Court and Commissioner Louise Bales Fightmaster denied me my ability to have that hearing while holding my license for a total of 8.5 months, when the law clearly stated, Family Code 17520 says they are to have a hearing within 30 days or return the license. They do get a second bite at the apple for an extension of 30 days. It wasn't filed in this case. And they get a third bite at the apple further down in the convoluted law, where you can ask a judge, like I did Commissioner Fightmaster. And at that point, the judge has 20 days to give you a hearing. All this can be verified by a simple review of Family Code 17520. Now, on page 4, down at the bottom, I was asking for that hearing in the court that day for my license. And the judge says, you have to file it with the court. If you want a hearing, you have to file paperwork with the court. And that's what I'm saying today. I'm treating your oral request as if you did file that paperwork. But the fact was I did. I responded to the notice. I sent in a letter stating, hey, I'm challenging your law. I want a hearing, an administrative hearing, which is what the Child Support Division gives you. And they told me, no, you're denied. That's a violation of your constitutionally protected civil right. Now let's move to page 5. On page 5, we look at line 11, where I asked the judge about the Southwick matter, and she says, I'm painfully aware of that case. Mr. Southwick was a litigant that I had met in court. I was at his hearing when he was asking for a hearing. And Commissioner Fightmaster was so frustrated that he kept pressing for his hearing that she said, and now your driver's license is gone. She hit the gavel on the bench and walked off. So for asking for his constitutionally protected right, Mr. Southwick lost his driver's license in addition to his contractor's license. That is completely illegal. So we finished with the first transcript. The last page, page 6, is a document that just states from the transcriptionist when you got the document. Now let's go to the second transcript. This was obtained 2 years later. We're again going to look at page 1, and we're going to go down to line 19. On line 19, we can see that I'm listed in pro per. Now, that would beg a question. Am I represented by a public defender, or am I in pro per? So let's look at the case summary submitted by the defense in that case, which is certified by the court. On page 48 of that case summary, you can clearly see the highlighted section says, I was represented. So that would mean this second transcript starts out altered. Let's go to page 3. We're again going to look at that line 5. We say again, it's a public defender matter. How am I in a quasi-criminal court for contempt and I'm in pro per? No, you have to be represented by a lawyer. That's why they give you the public defender. Second, let's go down to line 16. If you remember on the previous transcript, my lawyer says, Your Honor, and addresses her about my licensing issue. But on the second transcript, Kirk Gorman, who is the county's prosecutor for the Child Support Collection Division, is the one speaking what my lawyer said, and my lawyer's words were erased. Again, where is this legal? I know working at the courthouse, if you walk in any court clerk's area, there's always a note on the wall. If you take, bend, fold, mutilate, change, steal, if you do anything to the court record, it's a felony and they will charge you. So how is changing a transcript legal? I just don't get it. Okay? Finishing with page 3, though, let's look at that last line 28. They changed the word should to shouldn't so that I am telling the judge I shouldn't have custody. And that is not what I said. Let's look at the next page, page 4. Let's go to that line 5 area where the judge was addressing me about taking the license. She says, it's done. There's nothing I can do about it today. I won't today. I don't take it. The state takes it. And then in the second transcript, there's an added line that wasn't in the previous transcript. They add, they don't even take it. Now, these transcripts again are supposed to be exactly the same. How is it there's an added sentence? It just baffles the mind how this is legal. How a federal judge like William Wark III could see evidence like this and rule that a judge has absolute immunity to corrupt the record. Let's look at the last page on page 5. If we look at line 20, she was addressing the fact that I had addressed her on that case with the Southwick matter, and she was telling me that it didn't happen that way. But on the second transcript, there's another added line where she says, I'll look at it in October. They never looked at it. They never offered me the hearing. All they did was have a contempt hearing a month later, because all they want is money so that they can get the matching federal funding through Title 4D. And this is what I go through in family court, and I'm a part of the system. I work for 15 investigators. I piece cases like this together all the time. So why they would try this with me baffles the mind. But if you need one further proof that these transcripts were altered, you look at the case management statement by the defense in that federal filing. And in there, the defense counsel states, this is the judge, Commissioner Louise Bales Fightmaster's lawyer, the county lawyer, and the attorney general, said during the state court action, plaintiff demanded for an administrative hearing for the alleged wrongful suspension of his license was denied by the defendant, Commissioner Louise Bales Fightmaster. Now, how could she, in the transcripts, take an oral motion for a hearing when her own lawyers say she denied me? Something needs to be done about this, and dismissing the case is not an option. So, if you can't alter a case document legally, these transcripts prove 3 of the 5 elements of a fraud upon the court. I'm probably the equivalent of a first-year law student with the amount of time I've worked in the legal field. So how did a federal district court judge miss facts like these? Or were they just simply ignored because no pro per litigant is going to get a favorable ruling when suing a judge for monetary damages? No lawyer wants to take the case. It's career suicide. Judges need to be made accountable if they break and violate the law, because they do not have absolute immunity. So, with documented evidence like this, the district court dismissed my case, claiming the judge had an absolute bias. The Ninth Circuit Court of Appeals wouldn't even allow me in the door to argue my appeal, and they wouldn't assign me a lawyer. Because in the legal community, going after a judge is a career death sentence. There is a clear bias against pro per litigants, and no judge is going to allow a pro per litigant to prevail in a court of law and obtain a remedy or money from a judge who's been caught breaking the law, even if that law is your constitutionally protected civil rights. Remember, Roe versus Wade was one case. Brown v. Board of Education was one case. Andrews versus Department of Consumer Affairs is one case. And this case begs the question, where do we go when judges won't even uphold the Constitution? Here at Kids Matter, our vision is to create a society where all children get the love they need, and parents' rights to love them is guaranteed in the law. Our mission is to fundamentally reform the family justice system, to eliminate bias in the law and the exercise of judicial discretion, to create a fairness for all parents and protect the interests of our children, and to give those children a voice. Because kids matter.
KidsMatter.Charity, a nonprofit dedicated to fighting for kids' rights in difficult divorce situations. Donate at KidsMatter.Charity to help them restore common sense to the family courts.